April 1961. Most wanted Nazi criminal Adolf Eichmann faces court in Israel. A small, shabby-looking man, Eichmann's appearance flew in the face of how people viewed the architects of the Holocaust. His trial would reshape perceptions of war criminals, shining a light on the horrors of the Holocaust in a new way. It would become one of the most iconic trials of the 20th century and initiate a global wave of prosecutions of Nazi war criminals who had evaded justice in the decades after Nuremberg. But even as the evils of World War II were prosecuted, new blood was being spilled, sparking the next generation of international criminal tribunals. Decades after Nuremberg had ended, what had been learnt? The horror that was World War II was unprecedented in human history. Tens of millions died on the battlefield, and in appalling atrocities. But out of the chaos and suffering, the victorious Allies sought justice for those who had been wronged, in the hope of preventing such crimes from ever being committed again. In pursuing the guilty and exposing the truth, who would be held to account? And who would escape justice? Compromised by politics and the desire for revenge, the pursuit of justice was imperfect. Yet these trials redefined international law and shaped the modern world. This is World War II History on Trial. In 1945, among the ruins of war-torn Europe, the Nuremberg experiment had promised a new era, an era where the crimes committed in war would not go unanswered. But following the major trials of the 40s, the Iron Curtain descended and many of the guilty were allowed to vanish into new lives. A collective silence had settled as societies chose forgetfulness over reckoning. But by the 1960s, things were beginning to change. Technology was shrinking the globe, making secrets harder to keep. And a new generation was coming of age, one unwilling to inherit a world of silence. And one of the first cracks in this post-war malaise was the trial of Adolf Eichmann.
On trial in Jerusalem, the former SS Colonel Adolf Eichmann waits with his guards in a bulletproof glass dock.
The trial of Adolf Eichmann in Jerusalem, 1961, was arguably the most significant and famous trial of a Nazi in the post-war era.
It exemplified a shift from international war crimes trials, a la Nuremberg and Tokyo, to, you might call, the domestication of war crimes. So where trials begin to take place within states rather than an international tribunal.
It was a media sensation. Not only was this trial occurring in the new era of television and mass media, but the story of how he was brought to trial was astonishing. Like many Nazi criminals, Eichmann had fled Europe to Argentina through the notorious smuggling routes known as rat lines.
The rat line was basically a way of getting people who were accused or tainted by a Nazi past out of Europe and to South America.
It is estimated thousands of former Nazis escaped Europe through the rat lines.
There was a large group of Nazis in places like Argentina and Brazil, and some of the major figures, Joseph Mengele, the Nazi doctor, Klaus Barbie, the butcher of Leon, Adolf Eichmann, and it's likely that they are the tip of the iceberg.
Under the orders of Israeli Prime Minister David Ben-Gurion, Israeli agents kidnapped Eichmann and smuggled him to Israel to face trial. Eichmann was charged with crimes against humanity, war crimes, membership in hostile organizations, and crimes against the Jewish people. Eichmann may have seemed superficially ordinary, but he was in charge of the deportation of more than 1.5 million Jews from all across Europe to ghettos, death camps, and other sites in the Third Reich.
I would describe Eichmann as the chief logistical officer. He was a Schreibtischtäter, which means a desk perpetrator.
When Eichmann appeared, he did not look like the sadistic monster most expected. His demeanor and appearance were extraordinarily ordinary. Could this man really be responsible for the death of millions?
In the words of one of the Israeli psychiatrists who interviewed Eichmann, he described Eichmann as terrifyingly normal. It's too easy to think that these state-sponsored mass atrocities are the work of rogues and psychopaths. It's much more disturbing to think that, no, ordinary people, they will help implement these truly horrific acts.
But so there is this contrast between this regular guy sitting in the courtroom, taking notes and so on, and then the exceptionally brutal nature of what the witnesses in front of him recounted.
Eichmann's defense, headed up by German lawyer Dr. Robert Servatius, largely did not challenge the events, nor did they dispute the evidence. They leant on a now well-worn defense, that the defendant was just following orders.
In the spirit of the indictment, I am not guilty.
Eichmann himself was the sole witness for the defense and said of his own culpability, "The men at the top, the elite, the popes of the empire, laid down the line to be followed, and I had only to obey." Eichmann's trial punctured the myth that those responsible for the Holocaust were largely sadistic murderers and torturers. Evil could appear unremarkable. It could be sitting behind a desk. And this wasn't the only chilling truth the world was forced to confront.
The Eichmann trial was really the first trial of global significance that trained attention on the Holocaust.
For many in the broader public, Eichmann's trial would be the first time they heard directly from the victims of the Holocaust. As Attorney General and Chief Prosecutor at the Eichmann trial, Gideon Hausner said in his opening statement, "When I stand before you here, I am not standing alone. With me are 6 million accusers."
The Eichmann trial is often portrayed as the trial of the witnesses. And as such, it is also seen as the moment in which the victims get the central stage.
The voices of Jewish witnesses were broadcast live on the streets of Jerusalem. Around the world, print media and nightly news programs gave daily updates. And this type of testimony gave the Eichmann trial a personal edge that shocked and horrified the public. Unlike the Nuremberg tribunal, the Holocaust would not be buried in reams of documents and memos that sterilized the horrors of the Jewish experience.
One of the criticisms of the Nuremberg trial was that it didn't take the Jewish experience in Europe between 1933 and 45 seriously enough. When it came to the death camps and the extermination camps, it sort of folded Jewish victimhood into Nazi attacks on enemy civilians. So it rather underplayed the Holocaust. the Eichmann trial was important because it was sort of Nuremberg, but through the eyes of Jewish victims.
The trial starts to play this commemorative function rather than simply an evidentiary function. We are commemorating and honoring the experience of these people who have gone through these acute episodes of state-sponsored crime.
By the testimonies of more than 100 witnesses and evidenced by some 1,600 documents, the court heard a comprehensive account of the Holocaust of European Jews. Country by country, camp by camp, their stories were told.
The witness, yes, every child from the age of 6 up had to wear the yellow star.
And Eichmann's culpability was demonstrated.
A witness stood up and couldn't say anything at all for several minutes, and I think fainted. And that was often thought to be one of the most articulate comments on the horrors of the Holocaust.
The witnesses themselves helped to build the case against Eichmann.
Giving evidence is often a cathartic experience for an eyewitness to an atrocity. It causes them to endure the experience that they've gone through by way of memory. It's actually quite powerful evidence from a strategic or tactical point of view for the prosecution if you have someone appearing before the judges and describing the experience they've been through.
A shocked and outraged world watched on as the trial played out. After a little over 4 months, the trial of Adolf Eichmann concluded in August 1961. The court reconvened in December of that year to deliver Eichmann's verdict.
The accused, together with others, during the period 1939 to 1945, caused the killing of millions of Jews in his capacity as the person responsible for the execution of the Nazi plan known as the final solution of the Jewish problem.
He was found guilty on all 15 counts. For his crimes, he was hanged on the 31st of May, 1962. Many lessons were learned from the Eichmann trial. It showcased the abominable nature of the Holocaust in a new way. Here were the lived experiences in the harsh light of day. And Eichmann himself was proof that Nazis were not all uniform-clad sadists and psychopaths. With such powerful testimony and the coverage of the media, the horrors of the Holocaust were much harder for people to ignore.
It brings us to what we could call a new wave of international prosecutions of people who have had a responsibility in the crimes committed during the Second World War.
Following the war, by and large, people had wanted to look the other way. Until Eichmann's trial, and Holocaust victims were beamed into people's living rooms.
One of the interesting and also important legacies of the Eichmann trial was the way it really brought Nazi atrocity back on the table in Germany. Germany today has the reputation of being the country that's done a very responsible job in confronting its past. That said, by the time that West Germany regains its sovereignty, let's say in 1950, until basically the mid-1960s, the record of the German judiciary in bringing Nazis to trial is dismal.
After Konrad Adenauer's election as Chancellor of the newly formed Federal Republic of Germany in 1949, he pursued a policy of rehabilitation towards former Nazi Party members in an attempt to unify the fledgling nation. He granted widespread amnesty for crimes committed under the former regime and removed prohibitions on former Nazis holding positions within the administration, judiciary, and military.
the Allied trials were over, denazification was over, and now we have to look into a bright future.
The amnesty had been a calculated decision by the government.
You cannot start from the scratch with no experience at all. Around 75–80% of these positions were in the 50s then taken over by former Nazi party members. Not only those who were formerly party members, also war criminals themselves. And they established networks that they would promote them, that they would rise higher in the bureaucracy, and they would manage to suppress a lot of prosecution.
But a new generation was coming of age in the 60s. A generation which had criticisms of the Federal Republic's policy of reintegration.
So many have escaped justice. It's not hundreds, it's thousands. And in the 1960s, progressively, there is a new generation in Germany, but also elsewhere. And so questions are rising about, is this okay that those people have escaped justice?
We will not allow Nazis to operate in Berlin. We will crush them wherever possible, because that is our moral and our national duty.
The Eichmann trial was important in driving this growing momentum towards a second global wave of prosecutions of Nazi war criminals. What's more, young Germans were pushing for action.
A new generation, born after the war, gets more or less adult at the time. It's now or never to prosecute those people.
And the profile of the Eichmann trial influenced this generation.
There's a tremendous amount of attention on the trial that's being paid in German print and visual media. It doesn't necessarily galvanize, but it also contributes to the final staging of really the only real important Nazi trial to take place in Germany in the 1960s.
December 1963. The first of 3 major trials of 22 officials from the Auschwitz-Birkenau complex began in the German town of Frankfurt. On trial were SS officers and capos, Jewish internees who had worked for the Nazis in the camps in exchange for better conditions.
The prosecution office accuses the 22 defendants of having taken part in mass extermination in the concentration camp Auschwitz.
They put together a set of accused, not unsimilar like in Nuremberg, try to cover the entire concentration camp reality, like guards, commanders, doctors, all sorts of people that were working in these camps.
At Auschwitz-Birkenau, the largest of the Nazi extermination centers, 1.1 million innocent people were murdered. Following war's end, a number of high-profile Auschwitz camp personnel, such as Commandants Rudolf Höss and Arthur Lieberhenschel, had already been prosecuted in the 1947 trials held in Krakow, Poland. But as many as 8,200 Auschwitz staff who had survived the war and escaped were never brought to trial. At the Frankfurt Auschwitz trial, some 360 witnesses, 211 of whom were camp survivors, testified against the 22 defendants. But the prosecution faced an uphill battle, as restrictions built into the Federal Republic's criminal code were ill-suited for the sorts of state-sponsored mass crimes seen at Auschwitz.
The statute of limitations had already told for all crimes other than murder. And so basically, if you wanted to charge someone who had participated in a mobile extermination unit, or if you wanted to charge an SS officer at a killing center, you basically had to charge them with either perpetrating or aiding and abetting statutory murder. Now, the problem with that is the statutory murder charge had basically been designed for dealing with ordinary acts of killing that had been committed out of revenge or out of bloodlust or out of greed.
Some individual acts of killing were easy enough to build a case against. Wilhelm Borger, for example, had murdered thousands, shooting some at random and torturing others with the infamous Borger Schaukel, Borger swing. But at Auschwitz, the vast majority of the more than 1 million murders were difficult to pin to any one individual.
You had to come up with evidence that basically somebody has been individually responsible for a certain act, which was almost impossible to prove.
Unless you could prove that someone engaged in one of these kind of hands-on act of killing, it became almost impossible to bring any charges against any SS guard or any accessory to SS killing.
To garner convictions under these restrictions, the prosecution would need to ease the burden of proof on each case. And so, the Hessen State Attorney General, Fritz Bauer, a German Jew who had spent time in Nazi concentration camps, developed an audacious plan.
And his idea was to kind of treat Auschwitz as basically a large criminal enterprise. And as a unified criminal enterprise, anyone, regardless of their action, who participated in what was essentially a killing machine would perforce be guilty of at least aiding and abetting that act of murder.
But the court rejected Bauer's ambitious interpretation of the law, effectively insisting that Auschwitz was not a collective criminal enterprise, but 1.1 million individual murder cases.
So as a result of it, you have these kind of perverse results, like the assistant commandant of the camp being convicted of simply aiding and abetting murder. Whereas you have the camp official who actually, let's say, took a prisoner and without authority beat that person to death, well, there you could convict that person of murder.
The judges sentenced 6 of the defendants to life imprisonment for murder, including Wilhelm Borger. 10 were convicted of the less severe charge of aiding and abetting murder. Their sentences ranged up to 14 years. This also meant that those 10 would be eligible for early parole under West German law, and a number of them would not serve their full sentences.
So what emerged from that was kind of a completely distorted conception of the nature of criminality at a place like Auschwitz. And it kind of almost fed this picture that the Eichmann trial powerfully resisted, which was Nazi atrocities were committed really by these kind of pathological figures. And that was really the hope of Fritz Bauer in organizing this trial.
Bauer lamented the trials as a failure, later complaining that it was a wishful fantasy that there were only a few people with responsibility, and the rest were merely terrorized, violated hangers-on, compelled to do things completely contrary to their true nature. Nonetheless, the trial and media attention did shine a light on the horrors in the camps.
The Auschwitz trial is going to play a very important role in German society in terms of awareness of what has happened, the possibility to speak about it.
I think it's not exaggerated to say that it was an eye-opener for very many people, because they were not aware of how widespread these crimes were and what Auschwitz really meant.
It was for the first time that the German public was really confronted with evidence of what was going on in Auschwitz. After the end of the trial, I would say the German public was different than before.
Although the vast majority of Nazis who committed atrocities at Auschwitz-Birkenau were never brought to justice, the Auschwitz trials at Frankfurt were a milestone moment. The trial echoed the growing desire, especially among young Germans, for truth, accountability, and a break from the silence of the past. And in 1968, this desire would explode onto the streets of not only Germany, but the world, as young people demanded change.
(1968), a year of change, a year of protest. Protest through vocal but orderly demonstration, and protest through murderous lunacy.
1968 was a year of fire and fury, as calls for revolution rocked the Western world. From Paris's barricades to Prague's crushed spring, voices rose against authority, inequality, and war. Students, workers, and dreamers filled the streets, demanding change, risking everything for a future unshackled from the past. And in West Germany, it was no different. Known as the 68ers, this largely student-led protest movement was critical of West Germany's political and justice systems. Systems that were infected with former Nazis. They believed Parliament was being held back from reckoning with Germany's Nazi past.
What is interesting to see when you look at the German history, that they're dealing with the past, and in Germany this is called Vergangenheitsbewältigung. The dealing with the past comes in waves. All of a sudden something happens, a new thing comes up. Germany has to deal again with its past.
The Eichmann trial, the Frankfurt Auschwitz trials, and the 68ers movement were a series of waves that have helped shape German society in the decades since. Since the 1960s, there has been a dramatic uptick in the number of trials of war criminals. Billions paid in reparations to nations and individuals who were victimized by the Third Reich. And apology after apology after apology from German leaders to victims of Nazi atrocities. But these bold admissions of guilt and acceptance of culpability has been unique to Germany among their former Axis partners. Compared to Germany, no Japanese court has prosecuted war criminals in the decades following the war. Official apologies for the actions of the Imperial Japanese military have been like islands in a sea of denial. And demands for reparations from victims of Japanese colonial rule and military aggression have routinely been ignored by Japanese courts.
The main problem, the fact that the Japanese government did not recognize legal responsibility to compensate the victims of war crimes.
Many of these unresolved claims stem from Japan's use of forced labor during the war. Millions of people from China, Korea, the Philippines, and beyond were forcibly removed and enslaved. Untold thousands perished in brutal working conditions across the Japanese Empire. One particularly egregious example of this is the Japanese military's use of the euphemistically named comfort women.
In the case of women who are forced into military brothels, catering to the sexual needs of the soldiers and so forth, they are known as the military comfort women.
It was a form of quite systematic human trafficking, women, girls, and even some boys, estimates as high as 500,000 people in the long Japanese war.
It is estimated that as many as 90% of comfort women died from inhumane treatment, violence, and sexually transmitted diseases by the war's end. For decades, the Japanese government denied the existence of the Comfort Women program, until the weight of evidence became too much to ignore. The systemic sexual slavery was only publicly admitted by Japan in 1993. And in 2000, the Women's International Tribunal on Japanese military sexual slavery was formed.
The government of Japan was served with notice of these proceedings and was invited to attend and participate. It has not responded to this invitation.
There was a women's tribunal in Tokyo brought about by grassroots activists, non-governmental organizations that reheard evidence. It was done as an effort to galvanize attention and perhaps force the agenda of getting genuine reconciliation. And it really kind of was the moment where people started understanding not enough yet has been done to bring justice to the victims of that crime.
This tribunal felt it necessary to pick up the baton dropped by the Tokyo Tribunal because those tribunals did not charge or adjudicate the responsibility of the accused herein for war crimes or crimes against humanity with regards to comfort women.
There is one aspect that I understand will be quite new, and that is the accusation of Emperor Hirohito.
Hirohito was, controversially, provided immunity from prosecution despite the Nuremberg Charter's claims of no impunity for anyone under international law. He lived out his days as Emperor of Japan.
There's no positive evidence showing that he ordered or authorized the use of women. There is a case to be made that he knew or should have known, given how widespread this practice was and how long this system lasted. Under the doctrine of superior responsibility, he could be established as having individual criminal responsibility.
And that is what the tribunal ruled, that Hirohito, as Emperor of Japan, was guilty of responsibility for crimes against humanity. Despite this, there were no long-term consequences for those found guilty at the tribunal. All the defendants were dead. But beyond that, despite closely resembling an international court, replete with experienced international judges and prosecutors, it was not legally binding.
The judgment rendered was not a judgment as we know it, because this wasn't a trial. It was meant to offer a place for the survivors of the comfort women system to be recognized of their sufferings and trauma and their courage to speak out.
Many that suffered at the hands of the Japanese imperial forces never got an opportunity to heal due to Japan's approach to atonement.
To this day, there is not a sense from the victim group that Japan has apologized sufficiently.
The Chinese government and the South Koreans have felt that Japan didn't always fully come to terms with the atrocities committed in those two states.
Ironically, Japan's stance on comfort women is at odds with their actions in other realms of international law. It is the third largest financial contributor to the United Nations, behind only the US and China. And as of 2019, it has contributed over $300 million to the International Criminal Court, or ICC. Located in The Hague, the Netherlands, the ICC is the beating heart of international law today. Established in July 2002, it is the first permanent international criminal court in the world. It is here that international crimes, including those first articulated at Nuremberg, war crimes, crimes against humanity, and crimes of aggression, are prosecuted.
In terms of Nuremberg, there were international prosecutors, international judges, and they rendered their verdicts. So that set in motion this idea of having international criminal courts, and that international humanitarian law would be recognised in a way that would act as a deterrent for people committing atrocities.
But the ICC was not formed until 56 years after Nuremberg had finished. And 54 years after the United Nations adopted the resolution for its creation. Why did it take so long?
The International Criminal Court was a goal of the United Nations from its first days. It was only the intervention of the Cold War that prevented it from coming to fruition in the 1950s.
In New York, at this historic meeting, the United Nations Security Council deals with aggression in Korea. The American standpoint is put by Mr. Warren Austin.
I am happy and proud to report that the United States is prepared, as a loyal member of the United Nations, to furnish assistance to the Republic of Korea.
The Soviet delegate tries to make propaganda from the truce talks. The American government obviously does not want to put an end to the war in Korea. It has been dragging out and stalling.
The Cold War saw the world divided into two blocs, led by the United States and Soviet Union. During this time, the United Nations was often paralyzed as each side jockeyed for power. In this climate, the formation of a permanent international criminal court floundered, all while international crimes flourished.
There just isn't enough agreement between the Soviets and the Americans to establish a permanent international criminal court. For example, it would be awfully difficult in that period for either the Soviets or the Americans to accept a court applying something like the crime of aggression, given that the Soviets and the United States committed acts of aggression in their various spheres of influence.
The dream of an enduring international legal body had arisen from Nuremberg, but the Cold War had frozen any progress. This began to change when the collapse of the Soviet Union ended the Cold War, clearing the way for political cooperation at the United Nations. And a series of bloody, genocidal wars erupted in its wake.
A lot of events of World War II really, in some ways, were a precursor and, most importantly, a memory background to the violence of the 1990s.
The War of Yugoslav Succession, often referred to as the Balkan Wars, lasted between 1991 and 2001.
In the early months of that conflict, there were news teams from the BBC, from Sky TV, from CNN. It was the advent of satellite news 24/7 television. They were broadcasting into the living rooms of people in America, Europe, Canada, Australia. Nightly, scenes of civilian devastation in Sarajevo, civilians being shot and shelled.
Massive war crimes and crimes against humanity and crimes against civilians were committed.
Then, in 1994, chilling violence and bloodshed swept over Rwanda. In just 100 days, some 800,000 Tutsis were murdered by militias, comprised of the Hutu ethnic majority.
The context of the violence of the 1990s led to a feeling of kind of international impotence. We are not able to stop these wars. We have all pledged after the end of World War II and the Holocaust, never again will we allow for genocide, and we now have concurrent genocide happening in Rwanda and in Bosnia.
The United Nations sprung into action, organizing the first international tribunals to prosecute crimes committed in war since Nuremberg and Tokyo.
The formation in the early 1990s of the Yugoslavia Tribunal and the Rwanda Tribunal is really quite surprising. The reason for that is that there had been several decades when nothing like this had happened. Indeed, when many people felt that the project of international criminal trials was just a dead letter.
In 1993, the UN Security Council established the ICTY, the International Criminal Tribunal for the former Yugoslavia.
Are you ready to enter a plea to the indictment?
Not guilty. I never took part in any of the crimes with which I'm charged.
The following year, it went on to establish a similar tribunal for Rwanda, known as the ICTR. Since Nuremberg and the subsequent trials in the late 40s, no international body had attempted to prosecute international law, and no national leaders had been brought to justice for the actions of their militaries.
I wish to state that
That was until Serbian President Slobodan Milosevic, the first European head of state to be prosecuted for genocide and war crimes, was brought before the tribunal.
It was incredibly important to see a head of state. Milosevic, when he was arrested, was a sitting head of state. It was very important to demonstrate that even very powerful people can be brought to justice.
Within 10 days of the issuing of that indictment, President Milosevic accepted proposed terms of settlement from the international community. So it's likely that the commencement of criminal proceedings against President Milosevic in fact contributed to a resolution of that conflict.
Both the Rwandan and Yugoslav tribunals were groundbreaking. The ICTY began in 1993 and ran until 2017. Indicting 161 individuals on charges of genocide, war crimes, and crimes against humanity, the tribunal convicted 93 individuals and referred a further 13 to domestic courts.
Sentencing proceedings.
Operating from 1995 to 2015, the ICTR indicted 93 people, returning 62 convictions and referring 10 to domestic courts. These convictions built on the established precedent set by Nuremberg, reinforcing that there would not be impunity for state leaders like Milosevic, and it managed to successfully prosecute the entirely new charge of genocide in dozens of cases. Yet despite these successes, the tribunals were not permanent. A seed planted in the ashes of World War II that lay dormant for almost 60 years had finally begun to sprout.
The momentum from the Yugoslavia Tribunal and the Rwanda Tribunal really snowballs. You begin to see many states feeling maybe this is a new solution. Let's not go to war, let's go to court. Not surprisingly, in that moment, the idea resurfaces, which had been the idea in 1945, was to have a permanent international criminal court.
"1998, Rome. diplomats from all over the world descend on the city to discuss the establishment of a permanent international criminal court.
We shall have a permanent court to judge the most serious of crimes of concern to the international community as a whole.
But many feared that the same political divisions that prevented the establishment of the court decades earlier would still be too great to overcome.
Criminal court. May it serve mankind well in generations to come.
Somewhat to everyone's surprise, they finish the statute. They solve all the disagreements they had about sentencing and what crimes and how many judges and what does the prosecutor do, and they adopt the treaty. And then 4 years later, in 2002, the court begins operations, and it's still in existence today.
On the 1st of July 2002, the International Criminal Court began sittings in The Hague. Modelled on the Nuremberg Charter, the charges it would adopt were the same which had been laid out at Nuremberg and Tokyo, with one new inclusion: genocide. Although plagued by similar political compromises that were seen in the aftermath of the Second World War, the establishment of the International Criminal Court was the culmination of an experiment almost 60 years in the making.
We must not forget to strengthen...
If we look at the last century, there have been two turning points. The first was the advent of the Nuremberg Tribunal, which was effectively the birth of international criminal law. The second is the creation of the International Criminal Court, which organically grew out of the first event.
That civilization cannot tolerate their being ignored.
The legacy of the Nuremberg and Tokyo tribunals are plain to see in the notion of individual responsibility over that of the state, in the ICC's form as an independent judicial process, even in the language used by diplomats, leaders, and citizens to describe conflict.
If we think about recent crises, we find ourselves talking in a Nuremberg language.
Needs to be trialed for crime against humanity and war crime.
The mission has concluded that criminal investigation and prosecution is warranted in relation to genocide, crimes against humanity, and war crimes.
This is brutality, this is inhumane, and this is violating international law.
So this is very much the basic language of statecraft and diplomacy today. And I can't really stress enough how new this is. So prior to Nuremberg, that would not have been the default language of either us as ordinary citizens or world leaders.
For the crime against humanity.
Nuremberg plays a big part in that story.
We never forget that our organization has its origins in a global struggle against regimes which were guilty of mass murder on a horrendous scale.
So IMT and IMT-FE left us with an important piece of jurisdiction, of jurisprudence. And they also left us with a narrative, with the first narrative of the war.
The Nuremberg trials at the end of the Second World War firmly established once and for all that there was not going to be any impunity for serious atrocities and crimes or genocide. Political realities these days are really undermining the importance of enforcing international criminal law. We cannot give up on the process. We have to keep focused on ending impunity for these crimes, and we have to make sure that those responsible for committing atrocities are brought to justice.